So I'll let you go. I don't think it's going to matter to the court because if a child's withheld against a court order, I don't know that that's a civil matter, but I'll let you have your definition. Go for it.
How long, when did you start working in law enforcement?
The last one.
That's the last one.
Okay, here we go.
See that? Very official.
Self-authenticated.
Is that? I'm not sure.
Ready? Court does call the case of the people of the state of Michigan versus Lovely.
Buckle up, guys. Today we are diving into a courtroom moment where the judge wastes absolutely no time setting the stakes. Right out of the gate, the court makes it clear this is not just a casual custody disagreement. When a child is withheld against a court order, the judge hints this may cross out of civil territory entirely. That opening tone instantly signals seriousness, authority, and looming consequences before the case is even formally called.
I think you would, good afternoon, Jonathan Memons on behalf of the people.
And Kenneth Overwater, Assistant Public Defender on behalf of Ms. Lovely, who stands to my right in court.
Okay, thank you. We're ready to proceed to exam.
Defense is ready.
People are ready to proceed in this matter. My understanding is that there's also some kind of a violation hearing. Did you want to do the exam and then kind of do everything all at once, or however?
Yes.
Perfect.
That's
Not that there's anybody else left. I'm going to call my first witness, is going to be Corey Johnson, but I have the officer in charge, Dusty Patel, also here with us today.
all right. Sir, please come forward. Be sworn.
I swear our firm testimony you're about to give, the truth of the truth, and nothing but the truth. State your spell for some of the record.
George, I think.
From here, the courtroom shifts into full procedural mode as the case is officially called and the parties are identified. What seems routine on the surface quietly builds tension because everyone now understands this is about a child, a prior court order, and alleged defiance. The father is called as the first witness, signaling that the prosecution intends to establish a clear timeline straight from the source rather than easing into it slowly.
All right, go. You may inquire.
Yeah, thank you. And good morning, Mr. John, or good afternoon, Mr. Johnson. Thank you for being here today. Just to kind of get right into it, with the court's permission, there's a child involved here. I'm just gonna refer to it as the child, so that I'm not putting his name.
That is fine.
And likewise, if defense could. Do you have a son?
Yes, I do.
Okay, and who is the mother of that child? Okay, and just identify her. Okay, and is that somebody who you see here in the courtroom today? And how do you know Miss Lovely?
She's white.
Okay, and you guys are obviously divorced then?
Yeah.
When was that divorce, when did that become effective?
2019.
Okay, and as such, out of that divorce proceeding, was there a custody arrangement that was entered into regarding your child?
Yes.
In September of 2022?
Yes.
Can you briefly tell us what the terms of that arrangement were?
Yes, we each had 50-50 custody, joint custody. And
Okay.
then we did our exchanges on Fridays.
Okay, and so is that one parent would drop them off at school, the other parent would then pick them up?
The witness lays out the background, a finalized divorce and a 50-50 custody agreement with structured exchanges through school. This part matters because it establishes that there was already a clear, court-approved system in place. Nothing here is vague or informal. The calm explanation contrasts sharply with what's coming next because it shows the situation wasn't chaotic until something disrupted it.
Yes, you complete your week by dropping them off on Friday, and then the other parent would start their week picking them up.
Okay. So I want to fast forward to Thursday of I'm sorry, February of 2023. Did anything change regarding that arrangement, that custody arrangement?
Yes, that, the first week of February, I would have had custody of my son. And I was contacted by stated they're investigating the claims that she had made against me. They turned out to be false. So I believe it was like the 6th, they contacted me and they said, we're gonna go back to normal custody. We advised her to continue like you should be, dropping him off at school, and I would pick him up, et cetera. And that never happened.
Okay.
Things take a sharp turn as the witness explains how CPS allegations suddenly interrupted normal custody. He states the claims were investigated and found to be false, yet the damage was already done. This segment quietly introduces the theme of escalation. An external accusation triggers a chain reaction that pulls courts, CPS, and law enforcement into what had been a stable arrangement.
So February 6th of 2023, I believe that was a Monday.
Monday or Tuesday.
Okay. You were supposed to have the child on what day? That Friday, so roughly the 3rd. I looked at a calendar earlier.
Yeah, I have to look at it.
Okay.
Well, hold on. I just want to make sure. On the 3rd would have been your pickup, the beginning of your custody.
Yes.
Okay. Go ahead.
And then that should have terminated with you dropping the child off on the 10th.
Yeah, Friday.
Okay.
Whatever the Fridays were. Got it.
All right. And so then now turning to the 6th of February, CPS gives you the okay to resume your pickup. Do you have any interaction with the defendant regarding?
Attention locks onto February 6th, the moment custody was supposed to resume and didn't. The father explains that despite clearance to return to the normal schedule, the child was never brought back. This is the pivot point of the entire case. Everything after this moment flows from the simple fact that the child did not return when the court system said he should.
The child exchange on the 6th.
Yeah, she contacted me on our family wizard.
Okay.
Told me she was not returning.
Okay. Prior to February 6th, had you been observing her social media feeds?
Yes.
Okay. And did you have any concerns about what the defendant was going to do with herself and the child?
Objection, Your Honor, as to the relevance of what's on her, allegedly on her social media feed, certainly with regard to what he may have speculated he was worried about her doing.
Well, but that goes to his state of mind as to everything. I'll overrule the objection. I'll hear it.
Go ahead.
Here, the case adds emotional weight as concerns about the mother's behavior surface, specifically through social media activity. A defense objection tries to shut this down, but the judge overrules it, allowing the testimony to stand. That ruling matters because it shows the court is willing to hear context when it speaks to intent, fear, and state of mind, not just dry logistics.
Yeah, so had you been kind of monitoring her social media?
Yes, I was concerned that she was going to take him out of state.
Okay. With a specific destination?
New York, that's all I knew.
Okay. And so did you share those concerns that you had with the defendant at all?
Yes, I told her that would be a violation. We were required to provide an itinerary to front of work, and that never happened.
Okay.
I verified that with Sarah Mazer. She said they hadn't received an itinerary, and that what she provided wasn't appropriate.
Okay. So on the 6th, obviously the child does not return to your care.
Right.
Okay. What happens then on the 7th?
I contacted and law enforcement referenced the issue. A order was filled out and sent to the judge by a friend of court to pick my son up and return him to me. That was signed by Judge O'Brien.
Okay.
The testimony becomes more specific and more alarming. The father explains his fear that the child would be taken out of state, even naming New York as a concern. He also explains that required travel details were never provided. This isn't speculation anymore. It's a claimed violation layered on top of an already broken custody exchange, raising the stakes significantly.
Did you anticipate that you were going to be able to pick up your child from school that day?
Yeah,
Okay. Did you reach out to the school at all?
I did, and they told me that he hadn't been brought that day.
Okay.
I think he said it was like mental health or something like that.
You obviously didn't. You obviously didn't excuse him. Okay. Okay. All right. The order. When you contacted friend of the court, were you able to receive a copy of the order from friend of the court?
I did.
Okay. I'm going to approach with what's been marked as people's proposed exhibit number 1. If I may, Your Honor.
Yes, you may.
All right, Mr. Johnson, that exhibit that I've handed you, you've had an opportunity to review that before testifying today?
Yes.
And is that something that you're familiar with?
Yes, this is the order that they sent to the judge. That she's
Okay.
trying to pick up.
Okay. And is that a fair and accurate copy of the order that was submitted and signed by Judge O'Brien at the 22nd Circuit Court?
Yeah.
Okay.
Got it.
And that's the order. What was that order informing what was supposed to happen with the child?
I believe, let me read it just to clarify. Says that she's supposed to return to me immediately and not leave the state of Michigan.
Okay. Your Honor, unless there's any objection or voir dire on the issue, I'm going to move to admit people's proposed exhibit number 1.
No objection for purposes of exam.
Exhibit 1 is admitted.
Did the court want to review that?
Yeah, I'll say.
Thank you.
Thank you. Standard order. Okay.
Now the court's authority comes down hard. An emergency order is issued and signed by the judge, requiring the immediate return of the child and prohibiting travel out of Michigan. The order is entered into evidence, anchoring the case in black and white documentation. This is no longer about interpretation or misunderstanding. It's about compliance with a direct judicial command.
Go
Thank
ahead.
you. So now turning your attention then, so that February 7th, that order gets signed. You said that you contacted police. What agency did you contact?
I contacted Northfield Township, and I believe it was a detective that called me back. He called me back.
Okay.
I sent him that document that I had by email, and then he basically said because of the multi-jurisdictional thing that he was going to forward it to the state police.
Okay. And as such, did you end up later that day speaking to Trooper Pitzel? Pitzel. It rolls off the tongue. Pitzel. Okay. All right. And where did you speak to him at? Where did he come to your house? Okay. You spoke to him over the phone. Did he? Well, you kind of explained the situation to him as best you could. Okay. All right. Moving forward to Friday the 10th, had you received custody of your child by the 10th?
No.
Okay.
The father describes contacting law enforcement, which elevates the situation again. Local police loop in the state police, signaling that this isn't being treated lightly. This segment shows how quickly a custody issue can move beyond family court when court orders are ignored, especially when a child's location and safety are uncertain.
Then moving forward to the 13th, that Monday, February 13th, by that point in time, had you received custody of your child? Okay. And it's your understanding that pursuant to the order, the child was supposed to remain in your care until further order of the court. Okay. All right. So then tell me what happens on the 14th of February. Had you, on the 14th of February, so this is Tuesday, had you received custody of your child? Okay. So what did you do, or what happened in terms of that custody arrangement?
And contacted front court and law enforcement and advised them that at that point she wasn't even in Michigan anymore.
Despite the emergency order and police involvement, the child still hasn't been returned. This short stretch reinforces the central issue. Time keeps passing and nothing changes. The court is being defied day by day, and each delay compounds the seriousness of what the defendant is accused of doing.
I
Objection, Your Honor, foundation as to where she was.
I can, if it,
Well, he is, as I understand his statement, whether it's true or not, that's what he's indicating. So there may not be foundation for what it is, and the court will give it whatever weight I give that statement, but I'm going to overrule the objection. Go ahead.
thank you. Go ahead. So I'm sorry, you reached out to friend of the court. You gave them some information.
Yes,
What happened as a result of that information?
they submitted another order to the judge. And this was for her, this was terminating her parental rights, and she had until the 24th. It's an ultimatum that she had to return them to the parental court by then. That was the latest, but it was to immediately do that.
The 24th of February.
Yes, sir.
Thank you. And if I may approach with people's proposed exhibit number 2. The 14th.
Yes, you may.
Thank you. Mr. Johnson, you've been handed what's been marked as people's proposed exhibit number 2. We just talked about the court order, the document in front of you. Do you recognize that item?
Yes.
Likewise, did you have an opportunity to view that before testifying in court today?
I have.
Okay. And is that a fair and accurate copy of the order that was submitted and signed by Judge O'Brien on the 14th of February of this year?
Yes, it was.
Okay. And unless there's any objection or voir dire on the issue, I'm going to move to admit people's proposed exhibit number 2.
No objection for exam purposes, Judge.
Exhibit 2 is admitted.
All right. So then,
A second, stronger court order is introduced, this time with explicit warnings and deadlines. The language escalates, signaling potential loss of custodial rights if compliance doesn't happen. This is the court drawing a bright red line. The judge isn't just asking anymore. The court is demanding action with consequences clearly spelled out.